My name's Abbe Brown, and I'm a professor in intellectual property law at the University of Aberdeen. I'm delighted with the opportunity to speak to you all today. I hope you're all safe and well, and we all are able to gather in person at some point. Special thanks to Karen, to Naomi, to Aisling, to all other colleagues and the funders who built the Patent Scholars Network. Today I'm going to speak about a title I've given Regulatory Transitions in Energy and Law, the Place of IP. I've been working on this since I finished a book exploring IP and climate change, and I've received some feedback on this at the Bailita conference and at ATRIP, and I'd really welcome any comments that anyone has. And there's a list of some suggested reading and some cases at the end. So I'm really interested in regulation of oil and gas and IP because I think they provide some really interesting insight into power. I'm slightly obsessed with power, but here I think we see some clashes of national IP rights and the power of other national regimes. And possibly when they clash, as I think there is the potential for them to clash, as I'll say, perhaps IP wouldn't win, and that's really quite unusual. And I think this can provide some really interesting insights for addressing some different societal challenges. Today I'm going to be looking really into how it seems that one regime might prevail over another and what future decision makers might think about that, rather than getting into the question of which regime actually should prevail. So briefly, IP and trade secrets can obviously confer considerable power. They confer the power to exclude activity by others, to stop rather than to do if you have met the criteria. And of course, although we often say it's a right to exclude, often the court may decline to actually grant you an injunction or an interdict in Scotland. These rights exist across all technologies, often specifically without reference to the technology. Nearly all countries are a member of the WTO, so pursuant to the TRIPS agreement, all countries will protect IP and trade secrets. Some flexibilities in relation to grant, in relation to power are permitted, they are not mandatory. And for countries at different levels of development, there are some transitional provisions. Other regimes can also have a lot of power. We often don't see those alongside IP. Today I'm going to be focusing on oil and gas regimes in the UK and in Canada. These confer, in relation to packages of land, a positive right to drill. You can go out and do this. In return for that, another analogy perhaps with IP, the quid pro quo point, you must pay taxes, but also you must disclose information to the regulator about what oil and gas is in your patch, and then eventually this will be shared widely. This was quite innovative, certainly in the UK. Traditionally, you would get your patch, you would drill, you would keep it secret as long as you possibly could. And as a result, it really wasn't known what oil and gas was in the North Sea. So addressing that has been seen as being a problem, and solutions have been developed. Both in the 1985 Canadian legislation and the 2016 Energy Act in the UK, if you do not disclose this information to the regulator for onward transmission to others, then your licence may be taken away. That is a real threat. Often we explore, and I'll touch on this shortly, clashes, say, between IP and human rights, IP sustainable development. It is extremely rare to meet a regime which may wish to do battle with IP, which has sanctions of anything like the ones which IP, with the possibility of an injunction, can offer. In the UK, this builds from the Maximising Economic Recovery Review, often called the Wood Review, from 2014. And this one's aimed, as it suggests, maximising economic recovery. How can the sector as a whole, working collaboratively, make as most effective and efficient use of what is out there in the North Sea? How can we encourage investment? And information and innovation were really important themes. This led to the retention of information and samples regulations from 2018, so really moving very quickly, which required that information was to be kept about the location of oil, and if the regulator wanted it, you had to share it. And then in the Disclosure of Protected Material regulations from 2018, it was made clear that information was to be shared onward by the regulator after particular periods. In some cases, it could be immediately, in some cases 2 years, in some cases 5 years, in some cases the end of the licence, but a lot shorter than, say, a copyright term, and certainly you couldn't keep it secret forever. And this information is now going into the National Data Repository in Aberdeen. So one can certainly frame this as the oil and gas sector can obtain and use information which is the subject of IP rights or is secret. I'm not going to spend time, although there are some cases on the reading list at the end, looking into whether there should in fact be copyright and the finer points of the requirements for database rights to exist. But I think there's certainly a view that at least database rights could exist, and undoubtedly this is information which the IP owner may wish to keep confidential. The oil and gas regimes do not address directly, or at least visibly, the fact that this information may be the subject of intellectual property rights. There was some quite detailed consultation, but this really had a focus on confidentiality. The consultation will look quite familiar to IP lawyers. The discussion was how long for these particular sets of information. This is why some of it is immediately, some 2 years, some 5 years. What is the appropriate period for the oil and gas licence holder to have been rewarded for their investment? And after that, it's to be shared with everyone. Now, some people might really like this as a solution to some of the IP challenges that we've all been thinking about over the years. This consultation, however, did not refer to IP, very limited even references to it in the consultation. It's also interesting to note that there was lots of industry support for this new regime being put in place. Now, partly this could be, well, Company A might not want to share its information, but it will get access to Company B's information, so perhaps there's an element of that. And maybe a genuine community approach. It was led by a notable industry lead. Everyone was involved in it, and perhaps there was a feeling that they need to keep the sector alive. One can also frame this as a rare loss for IP. Other goals, keeping the lights on, better and more sustainable oil and gas recovery. And remember, we're putting to one side whether that is in fact actually a good thing or not. But this was the competing goal with traditional innovation incentives, and oil and gas won. Competition in exceptional circumstances, of course, as we saw in Microsoft and IMS, we can see competition requiring, through compulsory licensing, the sharing of intellectual property rights and limits on when an injunction might be granted, particularly in relation to standards. Key to that is the whole question of what does FRAND mean? Fair and reasonable non-discriminatory basis, of course. Still don't know what it means. Now, there are other clashes, which I've spent quite a lot of my career looking at, and there's some references in that in the slide at the end, how IP compares with human rights, how IP compares with climate change. But although there's valuable work arguing that these regimes are more important than intellectual property is, which I may well agree, structurally it's incredibly difficult to actually bring that about. So this is why I think it's so very interesting that we have an oil and gas regime setting out which very clearly, but without engaging specifically with IP, requires disclosure of information, which no other sector has actually been able to do. And it's particularly interesting, some work I'm doing just now in relation to marine biodiversity. A new UN treaty is being developed for areas beyond national jurisdiction, and there is real reluctance to even talk about IP. And a real fear of interfering with the power of IP, of interfering with TRIPS, of removing incentives to innovate. And these are simply not things which we have seen in oil and gas. And I like images like this. I find it really set out the situations. We've got parallel regimes. Then we have regimes actually talking to each other, but perhaps not really going anywhere. And sometimes you have a real fight. And we seem perhaps to have had a real fight in IP and oil and gas, and IP doesn't seem to have won. But maybe that's not quite so. Now, we might not need to talk about a fight, because we noticed that certainly in the UK so far, the industry does seem very much on board. But the oil and gas regime also, it has its safeguards. It provides that meeting the new regime is not to breach other laws. Reference is made non-exhaustively to competition, health and safety and the common law. Certainly common law may cover trade secrets. The National Data Repository's Registered User Agreement acknowledges the IP rights of users, people who would have put the information in. The Oil and Gas Authority Use Licence Agreement states that it doesn't affect exceptions to copyright in database and permits non-commercial use, but not commercial use. So perhaps this victory wasn't really such a victory, wasn't meant to be such a victory after all. But if that's the case, well, if we're assuming that at least database rights may exist, then is there a fight brewing? If we were to fight in the UK, copyright British Leyland and Armstrong, if copyright does exist, big infopack question mark, then perhaps non-derogation from grant might apply. There may be new application of the residual public interest provision. There may be new opportunities in relation to crown copyright, and interesting points there around from Canada in Keatley surveying. In database, Schedule 2 of the regulations has an exception to the database rights if the database is open to exception pursuant to public requirement. And I think that could apply here. It is narrow, it doesn't apply to all public databases, but here it is talking about scientific, technical, commercial, economic interests. So some situations I think this would apply. For trade secrets, there may be new scope for the public interest defence and legitimate interest under the Trade Secrets Directive. And at a practical level, the court may simply decline to grant an injunction or interdict. But a fight might happen, and in Canada a fight did happen. We'll recall that the legislation there was much older. It wasn't until 2017 that this fight did happen. And firstly, for those of you who are saying she really can't assume there would be copyright in Where Does the Oil and Gas Live? Well, the Court of Appeal of Alberta found that it did. It considered that seismic data compilation, Where's the Oil and Gas, is an expression of the subsurface of the area surveyed, not a feature of the landscape. The court considered the oil and gas regime created a compulsory licence regime after the confidentiality period expired, with no compensation. This new oil and gas regulatory regime had been created, and this was a complete answer to claims for unlawful disclosure and copyright infringement. And this balancing act between the need for more information about energy to be out there to the industry was an appropriate answer to the arguments of encouraging innovation, which had been argued by the copyright owner. From a statutory interpretation point of view, they also said that the Petroleum Act was more specific and more recent than the Copyright Act. But the court also was not willing to say there could not be an implied exception, and considered that there was no compulsory licence compensation argument because exclusivity ended. And sadly, there was no leave to appeal to the Supreme Court. So there could be a fight, and copyright might still lose, even if one notes the other possibilities which are existing at UK level from a more practical level. And the story doesn't end there. Investor-state dispute settlement, which is one of the things I'm increasingly interested in the main because I think if we can frame a lot of IP disputes as about a large innovator as against a state who may not be quite so powerful, then investor-state dispute settlement enables the fight to take place between the two real actors. I think it's particularly interesting for the UK. I'm making this recording in November 2020. There may be a lot more trade agreements coming for the UK. And within these are agreements between states and groups of states, but increasingly they have a clause that says that a private sector investor from one country who invests in another country, they are to be protected by what the second country might choose to do with their investment. Now, interestingly, a lot of this started many years ago now, feel that, say, an oil pipeline might be nationalised. We are now beginning to see many agreements seeing IP as an investment, and we're beginning to see some case law. There is a huge dispute and some invaluable collection by Christoph Geiger, which is on the reading at the end, which explores all of this. For now, it's interesting to note that after the Canadian Court of Appeal found against the copyright owner changed path, jumped to another regime, which again always interests me, and raised an action under NAFTA directly against Canada, complaining about its legislation, complaining about its court decision, and arguing this was in breach of fair and equitable treatment and no expropriation without compensation provisions. We don't yet know what's going to happen. An interesting analogy is another IS decision, again against Canada, by Eli Lilly, regarding a utility test to be met for a patent to exist. Now, it can only be indicative. ISDS decisions are not binding, but the court did find here that a new approach to utility was not entirely radical, it wasn't entirely unexpected, and so the the action failed. Eli Lilly did not succeed. So it's interesting to wonder how the GSI decision might be viewed. On one level, it could be seen as a fairly standard application of statutory interpretation. On the other hand, it could be you have ripped up copyright law and put another law in its place. That might be seen as very, very radical, very unanticipated. So I think that will be quite fascinating. Interesting, at national level, it had been argued by the copyright owner that if the Parliament had wanted to get rid of copyright, they would have said so. And that didn't work well at national level. So what can we draw from this? I think it's a really interesting reminder that no rights are absolute. They come with obligations, and whether that is to a right to drill for oil and gas, or whether it's copyright or database or trade secret. It's very interesting to compare what one can frame as a battle of equals between an intellectual property owner with a right which gives you a very clear pathway to court. Whether you want to do it, whether you can afford to do it, are of course other questions, but a clear path to go to court as against a very well-funded and very aggressive oil and gas industry, who is also very clear what it wants, and rather like on that IP owners normally tends to get it. So this is where it is a very different landscape from the more public-private divide, which one tends to see more in, say, IP and climate change and IP and human rights. But again, where we also see this public and private sphere going through the debate. A reminder that rights can be limited internally, but also externally, and it is very important to be looking extremely widely. The fact that, say, energy lawyers might not be so familiar with IP does not mean that IP is not relevant. A better solution, which would at least have created greater clarity, which had been a real aim of a lot of the changes which were going on, was to talk about IP directly in national IP law and talk about oil and gas and vice versa, so they both talk to each other. That wasn't done. It's interesting to think about, although I think this threads very important light on rights, are we really talking much more about governance, particularly when we're talking about governance of oil and gas? It's a very familiar term. Governance of innovation isn't quite something that we see so much. And then within this landscape, I think really interesting to reflect on what gives the power, what does determine whether an outcome is going to happen, what means if you're going to win or not. Does it depend on the goal you are pursuing? Does it depend on how much money you have behind you, how powerful your industry is? Does it matter if you have a regulator who is really quite determined to act? And the goal of energy, of oil and gas, the establishment of a new regulator and a very wealthy industry can at least seem to have had much more effect than the equally, if not probably much more important goals of human rights and climate change. So that, I think, is interesting. But it's also very interesting because it does suggest, bearing in mind the points I made earlier, but it does suggest that there are actors and legislators and policymakers who will be willing, in some circumstances, to prevail over IP. And I think, particularly given where we are just now, that's a very interesting question. I'm going to leave that there. I hope we have the opportunity to speak together face-to-face or online about this. There's some things at the end which might be of use. Thanks very much. Bye-bye.